वी ऑल नो कि एनपीओस के केस में 30 सितंबर से पहले आपको अप्लाई करना है। अगर आप लेट हो जाते हो तो विद कॉन्डोनेशन ऑफ डिले करना है। और आप सब एटीट्यूड जानते हो डिपार्टमेंट का, वो क्या है कि जो तो हमारे 4-5 लिम्स हैं मेन, उसमें तो वो इतनी दिक्कत नहीं करते विद कॉन्डोनेशन, लेकिन जो अदर जनरल ऑब्जेक्टिव ऑफ पब्लिक यूटिलिटीज है, उसमें कई बार विद कॉन्डोनेशन वो दिक्कत कर सकते हैं। तो इन सबको ध्यान में रखते हुए वी रिक्वेस्ट वन ऑफ द most sought after speaker, rather he is number one in India, because when in 2023 the new form 10B as well as 10BB was introduced. At that time, Sanjay Agarwal Bhai was the chairman of the Direct Tax Committee and Piyush Shajar ji was the vice chairman. एंड मेरे को इंस्टीट्यूट ने उस समय कोऑर्डिनेटर की भूमिका में रखा और हमने 3 प्रोग्राम किए विपिन भटाविया जी के साथ, देवन शाह जी और हमारे मेहता जी भी साथ में थे इंदौर से। और उन प्रोग्राम्स में जो आईसीआई की तरफ से ऑर्गेनाइज हुए उसमें मोर देन 8,000 9,000 संख्या रही, क्योंकि 10BB और 10B में जितनी भी क्वेरीज थी वो विपिन जी ने और देवेंद्र शाह जी ने और मेहता जी ने बखूबी उनको दूर किया। दैट्स वाई हम 2 साल 23 और 24 में 10B और 10BB को एरर फ्री फाइल कर पाए। तो ये साल भी हमारा बहुत इंपॉर्टेंट है, क्योंकि हम सब जानते हैं कि 30 सितंबर, ऑल दो मैंने इसके रिगार्डिंग 7-8 रिप्रेजेंटेशन दे चुका हूं मैं पीएमओ को कि रिगार्डिंग 12A की जो रिन्यूअल की एक्सटेंशन के लिए, लेकिन जब तक एक्सटेंशन नहीं होती इसमें हम रिस्क नहीं ले सकते। दैट्स वाई हमने इस इंपॉर्टेंट डे पे ये प्रोग्राम रखा। और दूसरा, संजय अग्रवाल जी will join us because he has to rush to the Ministry of Finance Corporate Affairs due to some urgency, because many matters related to profession, maybe it be Big Four of Indian Big Four, that's why it is going on. That's why he has to rush to the ministry. He will join us later and will update if any with him latest related to the data station. I have 2 another updates I will share along with Sanjay Agarwal ji when he will join. तो सबसे पहले मैं जो हमारे आज के फैकल्टी हैं मुंबई से स्पेशली, जिन्होंने इतने बिजी शेड्यूल में से टाइम निकाला टैक्स ऑडिट रिपोर्ट और 12A के, हालांकि इन्होंने अपनी भी बहुत सी चढ़ानी है, अपलोड करनी है, और गौरव गुप्ता जी जो हमारे जोगेश बंका जी, और भी पैनलिस्ट में जो लोग हैं। और इसके अलावा जितने भी हमारे पार्टिसिपेंट अभी तक 220 पार्टिसिपेंट 221, जैसे हमने अब शुरू नहीं किया, 221 पार्टिसिपेंट हमारे लॉग इन कर चुके हैं। मैं आप सबका वॉइस ऑफ सीए और चार्टर्ड अकाउंटेंट एसोसिएशन जलंधर की तरफ से बहुत बहुत स्वागत करता हूं। आज का प्रोग्राम जो विपिन जी ने हमें इंस्ट्रक्ट किया है, दैट इज ऑन की इश्यूज रिलेटेड टू रिन्यूअल एंड री रजिस्ट्रेशन ऑफ एनपीओस। उसके ऊपर आपकी कोई भी क्वेरी है, ही विल रिजॉल्व दैट। टू स्टार्ट विद आई विल रिक्वेस्ट गौरव गुप्ता जी, he is also the co-founder along with me in the voice of CA, to introduce our today faculty CA विपिन बटाविया जी। एक और इंफॉर्मेशन मैं आपको दे दूं कि अगर आपका कोई भी फ्रेंड ज्वाइन करना चाहता है तो वो ज्वाइन कर ले। आज का प्रोग्राम ना तो हम यूट्यूब पे, ना ही हम क्लाउड पे, ना ही हम कंप्यूटर पे, कहीं भी हम रिकॉर्ड नहीं कर रहे।
गुड इवनिंग टू ऑल सर।
गौरव गुप्ता जी।
गुड इवनिंग टू ऑल मेंबर्स ऑफ this platform, Voice of CA. I know tough times are going for everyone, so thanks to all who have spared their valuable time and joining this another valuable session by Boka. CA Vipin P. Batavia ji is the most sought out faculty for this topic of the day. He is practicing chartered accountant since 1985 under the name Vipin Batavia and Company. He is practicing mainly in the area of direct taxes, audit, and achieved expertise on the formation and taxation of charitable trust and all related areas in the field of charitable trust, NGOs, clubs, and associations. Among his professional achievements, he has been president of Chamber of Tax Consultants in the year 2003-4, a very old and prominent tax bar of the country. He has been the office bearer of Chamber of Tax Consultants for more than 5 years. He has been the chairman of various committees and was chairman of General Committee of CTC for the 3 years of income tax reviews. He was actively involved in various committees of Bombay Chartered Accountants Society and WIRC. He has achieved expertise in the fields of charitable trust, handling every matter pertaining to charitable trust institutions, including Charity Commissioner, Income Tax, FCRA, and CSR matters. He is also the author of a book on the charitable trust published by Chamber of Tax Consultants. He has delivered many lectures and many fruitful discussions among various trade bodies, associations, and at various platforms in Mumbai as well as outside Mumbai also, particularly on the topic of formation of charitable trust procedures with the Office of Charity Commissioner and taxation of charitable and religious trusts. Among his proficient articles, he has written articles on various professional magazines and newspapers on charitable trust topic. He has represented before Standing Committee for the changes in DTC draft on charitable trust also and has been taken very well by the authorities. In real words, he is philanthropic in life and also is proactive in charitable activities, doing free activities for many charitable associations. He is an asset and a boon for every charitable society with which he is associated. Among this, he is also running his charitable trust and helping the society in various affairs and various matters, be it charitable organizations and associations in various capacities, including advisor and trustees of various trusts. Among all, he was National Secretary of All India organization called Dharm Bharati Mission. So, with these words, I request Batavia sir to please deliberate his session. He is such an asset for the Voice of CA and has been delivering so much lectures on the charitable trust. It will be a delight to listen to you, sir. Thank you so much.
Over to sir. Thank you, sir.
Yeah. Good evening, everybody.
Good evening, sir.
Respected Sanjay Agarwal ji, he is CCM of Institute, Central Council member. Ashwini Jindal ji is a host for the Voice of CA. My voice is clear?
Yes, sir. Yes.
Yeah. Mr. Gaurav, thanks for good words for my introduction. Mr. Yogesh, Amarjit, and Mr. Rakesh, the team of Voice of CA. Friend, first of all, I congratulate Mr. Sanjay Agarwal ji and Ashwini ji for running such a excellent, organization. Rather, it is a group. I think it's a group, and there is a teamwork, and your many teamwork are working with you and doing an excellent job and sharing the knowledge and time and efforts for the profession. That's a wonderful job. My congratulations and appreciation for all these things. Friends, charitable trust, NPOs. In recent time, we all know that since last 7-8 years, there is a continuous amendments in the provisions of charitable trust. There is a tremendous increase in the compliances. The amended provisions are such that these are complicated and not very easy to comply. And moreover, the provisions are just watertight provisions. If you miss a day, if you miss something, if you put a wrong section in the application, if you for any reason you miss something to fill up or you miss the due date, the repercussions are very serious. And particularly from the Finance Act 2020, many amendments have been brought in, mainly the registration provisions for NPOs under 12A, which was earlier procedure was followed under 12A, which replaced by 12AB. And these provisions are such that timelines are given for every types of renewal or re-registration. A new concept of provisional registration is brought in. And all old trusts were required to re-register. I'll just add here, okay, initially I will just brush up the provisions so that if you know those things, why and when, since when it is applicable and all this will be a helpful for you to make an application that which is due for re-registration, or rather it is renewal. Earlier, all old charitable trusts were required to re-register. Those re-registration were restricted to 5 years. Earlier, the registration were granted perpetual. Those perpetuality of registration will include in my lecture or in everywhere ATG as well. It goes simultaneously, except certain other requirements are there. Otherwise, 12A and ATG goes together. So it is now restricted to 5 years. And every 5 years, one has to renew and apply for renewal. And these new provisions are applicable from 1/4/21. It means from assessment year 22-23, the new provisions were applicable. The reason given for these all changes were that they want to verify all the activities of the charitable trust. Every 5 years, they want to check and then renew the registration. Another thing was there, the registration records were scattered all over India. All the commissioners were having their own registration register, and records were there. There was no any centralized records or data available to the government for their various study and purposes and for getting amendment or doing such things. For that, they wanted at one place, and every trust were allotted one unique number, registration number. Those data are now with CPC, because earlier the registration was done in form 10A. So there are two forms are prescribed, 10A and 10AB. So 10A was required to be filed for re-registration. So there was no any question were asked, only 4 documents, basic document, registration certificate, trust deed, accounts, and list of trustees. Those were asked, and the registration were automatically granted. Now the renewal time has come. In the renewal, they say, next slide, please. In the renewal, they have added new section, that is 12A1 AC, and proviso to 1 and 2 to section 1023C. So in this section, they have given 6 types of renewal registration, and different status are given. For that, different dates are allowed, different forms. Forms are 2. So 10A is applicable for re-registration, and 10A is applicable for provisional registration. Only for these 2 new registration, 10A form is to be used. All other subclauses, 10AB form is to be used. So now, most of the trusts will have obtained the registration for 5 years, that is 22-23 to 26-27. So the provision for re-registration renewal is that is in item number 2. Re-registration was there where they have allowed 1023C approval also for 5 years, 12A or under 12AA. It was also allotted for 5 years, that is assessment year 26-27. And the condonation provisions have also brought in, that we'll see on later slides. So second is, all the renewals are due, and the due date is, you have to apply at least 6 months prior to expiry of the set period. At least. So you are allowed to file before that as well, but certainly during the financial year. So now the 6 month is, we have to calculate the 6 month not from assessment year. 6 months is to be calculated from the date till which you are got registration, and the registrations are granted till 31st of March 26. So 6 months prior is 30th September. So the 30th September becomes the last date for applying for renewal of 12A and renewal of 80G. So both the applications are to be filed, and we all are aware since 10A were filed, both the applications are to be done separately, not one application. 2 applications separately are to be done. So the third subsection is provisional to regular. So we are presently concerned with that point number 2, subclause 2, renewal. Now renewal for 5 years or 10 years. 10 years criteria we will see, because they have amended last time, wherein a small trust can get the registration for 10 years. So that we'll see what are the criteria and whether they have to apply or not. Then the provisional to regular, whenever there is a provisional registration is granted, provisional registration is granted for 3 years from the year in which application is made. So any new trust, before the commencement of its activities, they can opt for provisional registration, and provisional registration is immediately granted for 3 years in the next month in which it is applied. So you get provisional registration immediately. I think now, next please. There is one more option was given in that subclause 4, inoperative, where there is, if you want to shift from 12A to 1023C or from 1023C to 12A registration. So that option was allowed. There is a new section was added, 11.7, wherein at least 6 months prior to the commencement of assessment year, you can opt for that change. And that change was allowed only once. We'll see later, because now that 1023C 4 to 6A subclauses are now sunset provisions. After 1024, no applications can be made under those subsections. So they all have to now renew under this subclause 2 only. And we will see later in more detail. Then if there is a modification in the objects of the trust. Now the trust or institution has adopted or undertaken modification of objects which do not conform to the conditions of registration. Back please. So there, if your objects which you have changed, if they conform the conditions for which it was granted, then there was no need to apply for re-registration. Otherwise, you are supposed to apply within 30 days from the adoption of or modification of those changes. So that part is to be very carefully to be kept in mind, because if there is a change in the object clause of the trust, you have to submit within 30 days for that. I just would like to add here, because in the new Act 25, wherein they have removed this condition, modification of the objects which do not confirm the conditions of registration has been deleted. Means every change you have to apply for registration. Because the trust or SSC is not entitled to decide whether they have to apply or not. Earlier, it was the decision of them whether they see if it is following the conditions of the registration, then there was no need to reapply. But now, after this new act will come in force, that portion has been deleted. There is an important subsection is 6. Now, earlier there was only one subsection of 6 only. Now it is 6A and 6B. So 6A says, if the activities are not commenced, the 10A form is to be filed and you are allotted for 3 years provisional registration. And that provisional registration is to be converted into a regular registration. And the conversion time is given within 6 months from the commencement of the activities or prior to 6 months of the expiry of the registration. So generally, the trusts which has been registered or newly formed, they will start activity within 1 or 2 years. So in that case, you have to be very careful that you have to apply for regularization of registration within 6 months from the commencement of activities. Now, commencement of activities is also a not clear what is to be considered commencement of activities, whether opening a bank account, whether acceptance of donations, whether some amount of establishment expenses are incurred, or whether the activity has been started. But the common view, and after discussion and everything, it has even the department are also accepted and the professionals have also accepted, and rightly so, because the trust is formed to do its charitable activities. The purpose, main purpose of the trust, why it is formed, to conduct the charitable activities. Now, the date on which you start or conduct the first charitable activity, that is the date of commencement. And this is the date of commencement has been accepted, and accordingly within 6 months it is to be applied. In case if earlier, if you miss that 6 month time, and generally it was so, you are in fix, because you cannot apply for the new registration because the part B is very important. So there is 6B if the activities are commenced. If you have no provisional registration and your activities are commenced, it means either you can apply for provisional registration before the commencement of activity, or you apply for regular registration for 5 years after the commencement of activity. So you first commence your activity and then go for normal registration for next 5 years. So shall we take questions in between?
अश्विनी जी, सर
As per your convenience, sir.
सर एक क्वेश्चन है इसमें कमेंसमेंट ऑफ एक्टिविटीज के ऊपर
जी.
व्हेन इज इट कंसिडर्ड टू बी ए कमेंसमेंट ऑफ एक्टिविटी कंसीडरिंग व्हेन सम डोनेशन इज रिसीव्ड वन और something is purchased to be distributed for charity, or actual distribution of the good to the recipient? When is it considered to be, because in some cases in Chandigarh tribunal, Chandigarh exemption ward, they are taking whether when you have taken a donation or when something is contributed to it comes in the bank, it is considered to be start of activity. 6 months start from there.
So it is IT judgment? Is it IT case law?
No, sir.
Or CIT is considered
CIT exemption is taking this plea.
See now this is also the area. Good, you have raised this point. One more panorama of discussion can be done on this issue, because all CITs have got their own interpretation. Even we see here in Pune, in Maharashtra, there are only 2 CIT exemptions. One is Mumbai, for Mumbai region, and another CIT is for rest of the Maharashtra in Pune. So now Pune CIT is taking different interpretation or view. Bombay is taking different. But so far as the commencement of activities are concerned, you see, this is my view. And here CIT is also accepted. Commencement is to be considered from the first activity is done. Because if you have received the donation, or if you receive a property on the settlement of trust, is it then you can say tomorrow you can expand that interpretation that a settlement amount received by the trustees is a commencement of activity? No, because the trust is not formed to collect the money. The trust is not formed to get the donations. It is incidental. But trust is formed to do charitable activities. The object of the trust, the purpose of the trust to do the charity. So from that perception, according to me and overall view in Mumbai, it is the date on which the first activity is done. That will be the date on which the commencement has started. It is commenced. Otherwise, you can collect the money for a few years, but no activity.
But when I talk to them, they say that in achievement of the activities, you have started collecting donation. So that means you have started something, taken action in achievement of the objects.
I tell you, it's that interpretation of that CIT.
That is of the CIT exemption. Yeah.
Correct. In law, nothing is mentioned about that.
Yeah.
And this has been discussed in law so many times, because the provisional is always every few months applications are going on. Commencement of activities. See, collecting money is not the activity. This is not the purpose of the trust. Purpose of the trust is not to collect the money and gather it.
I think this is what you are telling is the correct interpretation. I also replied in the same way, but anyway, they have different views.
That then you have to go to ITIT for that, because only they will understand what ITIT says.
Yes.
And another thing, one more thing. If suppose settlement amount is given 5 lakh rupees, so the same thing, the money has come to the trust, it has gone to the bank. So whether that is to be considered commencement of activity?
It is even before the settlement, before the
Trust is registered
even before the registration of the trust deed.
Right. So I think there is a merit on what we are contemplating here in Mumbai, and rightly so. I think you can argue very nicely with the ITIT. You will get the result. Yeah.
Thank
so
you.
now, commencement. I have to say something on that. See, there they have put a condition that the trust which has got started commencement, and the trust has never in the life of the trust claimed any exemption, whether under 11 or 1023C. So that condition is really giving trouble to so many cases. If they have lost provisional registration, if it is rejected and it is pending before the tribunal or some high court, and you are unable to apply for even 6B. So this position is not clear, because if you have claimed in past means if you had some registration in past and you have claimed section 11 or 1023C, so in that case you cannot apply in 6B. You can apply, but you will not be granted. So that condition is to be kept in mind for the commenced activities of the trust. Let's go to form renewal 10AB. See, there are a few more things. Earlier, the charitable provisions were specialized subject, because very complicated 11, 12, 13, 224 and 115 few sections. It was treated as a specialized subject. But after this amendment of 21 and onwards, now the charitable trust practices become super specialized. Because so many changes, so many circulars, so many judgments, so many interpretations, so many due dates are to be kept in mind. and repercussions are very serious. So this is what is, requires regular study, listening to such programs, reading yourself, discussing with your friends and others, so that the mistakes can be minimized. Friends, now we come to the application for renewal. Because now renewal is due, because 30th September. In fact, what rightly Ashwini Bhai has said, we are a little late, but whatever it may be, whatever questions we can clear, or whatever doubts I can clear, I'll be happy, because still there is a time, and I think there is seriously the matter is going on for extension of dates, including for the submission of application. Earlier, I was under impression that they will not go for extending these dates. But recently, I have come to know that there is a discussion and things are going on for these dates as well, because there are so many problems in so many clauses, there is no clarity for that. There is a very confusion in that. And just now, today, I think Punjab and Haryana High Court has told the departmental council to seek instruction and direction from CBDT by 26th of September.
Yes, sir.
Otherwise, we will decide the case our own. So they have given a date of 26th. There is today only Delhi High Court, they have filed a writ petition. Somebody has filed it. And Gujarat High Court is already going on. What is the development? I have no idea. But Punjab and Haryana High Court has said that by 26 you bring the direction or instruction from CBD.
There is from Rajasthan High Court also, sir.
Rajasthan is also there. But is there hearing is done in Rajasthan?
Some hearing has done, and same thing they have called for the instructions.
So date? Which date? Here it is given 26. So 26 is, still 5 days away.
In Punjab, it is 26.
Yeah. So now, the renewal application is to be done in most of the trusts who have got the registration up to AY 26-27. The category is trusts which are already registered, and or the institutions were approved for 5 years under 1023C. So they all have to apply. So that is first. Second is the application is to be made in all cases for re-registration granted for 5 years. That grant was there, I have already said 31/3/26, and by 30th September you have to file the application. So that is the deadline so far. Even in cases where approval were granted by 4, 6, 7, those also were all now required to submit for re-registration. Now I tell you one thing. There is an amendment has been carried out by Finance Act 24, wherein after 1/10/24, no approval will be granted for applications under 1023C, subclause 4, 5, 6, and 6A. These 4 subclauses are for different types of education, medical, then national importance, and others like that. So those now it is gone. But there is a counter amendment is there in section 12A, 12A and AB, 12AB, that those 1023C approvals which are expiring on 31/3/26, they have also to apply for 12A registration. Now they have to apply for 12A registration in the same form. Form is the same, applicable for both the regimes, first and second regime, both. And there they have to select the same subclause. Subclause 2, the section, and drop down it will come. And then now they will get 12A registration, and they will be entitled to claim 11 exemption, and all the conditions of 11 and registration will apply to them. So now that 100% is gone. Only thing is the earlier 1023C, most of the cases are expiring on 31/3/26. But any cases where after 21 they have obtained this approval, their exemption will continue till it has been granted. So that is already there. Now NPOs having 1023C, they have to. Next, please. Now, once you make application, see, there is a separate slides and what you have to attach along with the application. So that slide is later on. But after receiving the application, the CIT exemption or PCIT, generally it is with the CIT exemption, they will issue a notice for hearing and ask many number of questions and many number of queries they will ask for, and that you have to submit within the given time. And the CIT will see, and he has a power, call for such documents or information or make such inquiries as he thinks fit necessary in order to satisfy himself. So he can ask for any such documents, information, make any inquiries as he thinks fit. About the genuineness of the activities of the trust. Second is the compliances of such requirements of any other law for the time being in force by the trust as a material for the purpose of achieving its objects. I will repeat. The compliances of such requirements of any other law for the time being in force by the trust as a material for the purpose of achieving its objects. So it's the second part he has to satisfy himself. Thus the trust has complied on such requirements of any other law. Now any other law means every law is covered. But generally charitable trust, mainly the laws which are connected with the charitable trust, those are applicable. And third, B part is after satisfying himself about the objects and genuineness of its activities. So in B part, the section says okay, he has to satisfy himself for about the objects and genuineness. Actually, in the main section, objects is not mentioned. In the second B part, it is mentioned the objects and genuineness of its activities and the compliances of requirements as mentioned above. Pass an order in 1080. He may grant registration or he may reject. And that form is there, form that is in form 1080. So everything is in form. Granting is 1080, rejecting or renewal granting is in 1080. Here, I will take some time. See, it is the onus is on the trust to prove that the activities the trust is doing are genuine. Now, to prove genuinity of the activities, they are asking all details, accounts, everything for last 3 years. They might ask for 5 years. As a general law, they are asking for 3 years. For last 3 years, year-wise, you give the activities conducted. In the sense, suppose education. So education, Mr. So-and-so, fees is given this much. Even date by check, cash, that also if you can give. Or for any uniform, books, or any distribution of educational items and all those things. So you give the details of that. Likewise, medical, for medicine, for operation, for admission, whatever medical help you have given, give those details. Relief to poor, then any other object. Any other object, you have to be more careful. So there, those items, whatever you are giving details year-wise. Say assessment year 23, 27, education so much, these are the details, medical so much, these are the details, relief to poor so much, these are the details, and whatever other yoga you have spent or any other objects you have spent. So those, then you have to give the proof for those spending. In the sense, if you have given some receipts are there, their application is there, the patient's documents are there, some correspondence are there, some photographs you can give, some their pamphlets if you have distributed, or something, whatever you have done for conducting that activities should be submitted. Here I will advise, give as much as possible the information and details to the commissioner, so that your genuineness of the activities, which is the main thing he has to satisfy himself. So, proving our genuineness of the activities, you have to give all these documentary evidence and other evidences also. And in some cases, explanation for the activities, what kind of, some lectures are there, to where, what subject, how many attended. Or one more thing, if you can give the beneficiaries details, in the sense how many people must have been beneficiaries. Suppose you have given some good donation or something for a school, and the school children are there's 3,000 rupees, 3,000 students. So the beneficiaries are 3,000. So as much as information and details you can provide is advisable to me. Second is compliances for such requirements. Now this is something. So this portion you have to prove that you have complied all requirements of any other law. But with a rider, that which are material for the purpose of achieving its objects. If it is not material and those things, those compliances are not done, then that will not affect. But it is also subjective. What is material for the objective? Now, there are some states, there is a state law is there, Maharashtra Public Trust Act, Gujarat Public Trust Act, Rajasthan Public Trust Act, MP Registration Public Trust Act, and there are many states, there is no state law. So where there is a state law, you have to comply with those laws. But suppose if you have delayed in or not filed the accounts to the charity commissioner office, whether is it material for the purpose of achieving objects, or you have made any default in PF or ESIC or in this type of any other small laws, I think no, these are not material for the purpose of achieving the objects. Now suppose if you want to run a medical clinic, or in your office one portion as a homeopathy or allopathy or dentist or anything what you start, and you have not taken license from the local authority or the municipal or whatever the local authority is there, that is material for the achievement of the object. Or you are running a school, or you have not taken permission from the local authority, so that is material. Another is doubtful and very which is not yet clear, change in trusteeship. Now suppose there is a change in trusteeship, whether you have intimated to the required bank, you must have, every trust must have, they inform to the bank. But where there is a state law, whether you have filed a change report or whether you have submitted or not, whether where there is no any state law, but wherever it is required to be submitted, whether you have submitted those details or not, whether you have intimated to income tax or not, whether you have any other registrations are there now, which is Darpan. Darpan also is change in trusteeship to be intimated. So that is also become a mandatory. We'll see later on other slides. So here you have to be careful about that, because change in trusteeship, whether it is material for the purpose of achievement, because the decision taken by the trustees, whether it is valid or not. So now the decision taken by the trustees will be important for spending, where to spend, how much to spend. So in that case, I think that becomes a material. In such cases, you see that wherever the intimation is there, or you are supposed to intimate, you have intimated and comply with those laws. But there are certain, now in Maharashtra Public Trust, even Gujarat Public Trust, there is a provision for condonation of delay. Even if you file the change report late, they will condone the delay and accept the change. That is one question. Second is, in the trust, their record, they have decided those trustees are officially trustees in the trust record. It is just intimation is not given to the Charity Commission office. So this is also a, there are two views in that. According to me, it can be argued very well. Even that change in trusteeship may not be in certain cases material for the purpose of achieving its objects, depending on case to case. Then after satisfying himself about the objects, now all the objects of the trust should be for charitable purpose and for general public. It should not be for a particular community or caste. And none of the clause should be for the purpose of business or non-permitted business. 11.4 and 4A will see that are permitted. Which are not permitted, you should not have. Even recently in Mumbai, they are seeking whether if there is any activity clause is there for abroad, outside India. Now they are asking that you are intended to do the activity outside India, so that you should remove all these clauses. In fact, I will cover that later on in that particular clause. That is really something which is not required at the time of registration. But now it is their interpretation. They want, the trustees want the registration to be done. So they go to either Charity Commissioner or to the ROC, Section 8 company. They delete those words and come and submitting those applications, and they are granted. Earlier they granted on affidavit, but now they are asking the changes officially to be made. Welcome, Sanjay Agarwal ji.
Namaskar, sir. Namaskar. Sorry, actually, I was after that that date. People are thrashing me left, right. So actually, meanwhile, they got the information that people have gone to the court. So they have not yet said anything. They say that we have to take the legal counsel into consideration, and there is no news of any extension as of now, today or tomorrow. This is my submission. That is why I came in between, because I have to go to MCA also. There was an urgent meeting in the MCA. I have to go there. So with that is why I entered in between, and I on my camera so that Vipin sir should know it that I am there. So with this,
thank you very much. We are missing you.
I have two more information that from my another source that the all the writs representations has been put into the file, and the file has been moved to the finance minister, and hopefully she may decide even before that 26th date for the extension.
To end the litigation.
Rajasthan High Court is on 24th.
So 24th is no. So I think they will take decision not by tomorrow or day after tomorrow. That is for sure, according to me. So with this, I'm moving because a lot of people are with me. I have to go. Thank you very much, Ashwani ji. मैं हो सकता है फिर बाद में. Vipin ji, please continue.
Thank you, sir, for giving the latest information about this. We all are eagerly waiting, because all chartered accountants are suffering since last 1.5 months, and it is really and sky is not going to fall.
Yes.
In such a big country, if doing something relaxing the taxpayers and professionals, it is really the need of the day.
Yes, sir. So hopefully we'll get the extension. Thank you very much.
Oh, thank you, sir. Thank you very much. Now there is an amendment wherein they have said a small trust will get registration for 10 years. That amendment is gone in the last budget, wherein there is a doubt is created whether the existing small trusts have been granted extended for 10 years, or they have to reapply, and now they will get 10 years. So my interpretation in this matter is, there is no any automatic extension. The wordings in the amendment is such you have to apply and fulfill two conditions. One condition, unless you fulfill that condition, you will not be granted for 10 years. So first condition is your gross receipts, including corpus, specified funds and income, should be less than 5 crores. And in last 2 previous years, the gross receipts are also less than 5 crores. So comparison is not possible for already to those trusts who are given the 5 years small trust. But now they have to apply, they have to satisfy whether they are eligible for renewal, then only they will give for 10 years, otherwise they will reject. So that inherent power is already there, rejection and done. Only thing is that now small trust, if you are satisfying these two conditions, then you will get for 10 years. So from next 5 years, it will be 10 years. So that will be a great relief for small trust. Yes, please.
Yes, sir. एक क्वेश्चन ले ले सर. उससे पहले एक तो हैंड रेज है और एक हमारे कंबोज साहब का भी है सर.
सर इस केस में आपकी ओपिनियन बिल्कुल ठीक है. It has to be applied. It is not automatic. In one of my case recently, I got the renewal again for 5 years only. And the reply given by the CIT exemption is that your application was filed on 31st March. Since this provision is applicable from 1/4/25, my humble view before you is, please clarify that this is a procedural amendment. So they are to allow me the re-registration renewal after 1/4/25. So in my humble view, it should have been for 10 years. Even if I applied on 31st March or before 31st March on any day, but the application is taken up in the April month, so it should have been for 10 years.
I have sympathy with you. I tell you, Amarjit Singh ji, see, technically CIT is right. So if he allows you, then there will be question on them why you have allowed this. And you know, in department, what kind of questions they have to face and answer. So technically, I think he is right. And if sympathetically he should have allowed you. But technically, I think he's right.
Sir, kindly see, this section applies to the department. This is a 12AB procedure for registration.
Correct.
This section is for the department, not for the assessee to apply. The application is under the different section. So when they are giving me the registration after 1/4/25, it should have been that, because this is a procedural amendment. This is not a substantive amendment.
Then if you see the
because there is no clause there.
If they would not have given the date for effective date, then you are right. But there is a effective date given in the provision.
But effective date is for the grant of registration, not for application.
They are granting the registration, but the provision for you have been granted for which year?
वो साल लास्ट पे कर लिए क्वेश्चन है
24, 25, 25, 26 onward.
हाँ जी.
So how
26, 27 onward.
So 26, 27 is getting over, so he cannot give for that.
नहीं सर, मैं या तो फाइल मंगवा के
सर बात करते हैं फिर एक मिनट मैं दूसरे क्वेश्चन लेके फिर आगे चलिए सर.
चलिए बोलिए
अनुज गुप्ता जी.
Yes, sir. Sir, I have one question. Actually, I have my trust has a 12A. I have applied for the ATG, and the provisional registration has been granted. But like due to the ignorance and all, I couldn't able to apply for the permanent registration within the 6 months. Now it is being 2 years. So can I apply now because the 3 years period has not been lapsed? For the ATG, I'm talking about the ATG. And but sir, we haven't issued any kind of a receipt for the ATG so that the donor can the donor can claim. The donor can claim any kind of an exemption and anything kind of
Have you
stuff.
filed 10BD form?
No, sir.
Now the donations received and provisional registration approval of ATG is there. You are supposed to file 10BD.
But yes, sir. But he haven't.
That's
That
a
is the
default.
problem.
That's a default.
That is,
There is a separate penalty for that.
sir, what's the
No, but they
penalty?
have not received any donation, sir.
That is a separate thing. One thing I am asking
Okay.
is, in
Yes.
your case, you have not applied that within the
6 months.
available 6-month time.
Yes, sir.
If you have a reasonable reason, see, these condonation provisions are there only for 12A.
Okay. Yes,
Those
sir.
condonation provisions are not extended up to ATG.
Okay.
Now we have pointed out either it's a lapse or mistake, but there is no response. It means they have accepted their mistake. Oh no, it is gone. So for ATG there is no condonation provisions.
But
Now
sir,
in your case, according to me, now you have been given a temporary registration. Provisional is what? Temporary.
Right.
Now if you have not applied in that, according to me, purely technically, your provisional registration is gone from day one.
Okay.
Now,
sir,
but in ATG, you can again apply for that and you will get from the current year.
Next question.
Yes, sir. Basically, I just want to know, and that the thing is, because I haven't issued any kind of a receipt and all.
That doesn't make any difference to the provisions. If you have claimed then this and you have allowed then this and you were not allowed and this provision, it is not like that. Now your provisional registration is gone. You can apply afresh, and because that claiming of section 11 is deleted from ATG provisions.
Next, sir.
Now you are entitled for getting the fresh ATG registration. Now if you apply this, you will get from this year. Yeah, please next.
Next जी प्रयास जी, आपका हैंड रेज था प्रयास अग्रवाल जी, देन अनुराग अग्रवाल जी, जल्दी पूछिए क्वेश्चन, फिर हमने आगे निकलना सर, मतलब कि आधा घंटा रह गया फिर।
सर मेरा तो फॉर्म शुरू नहीं हुआ है।
हाँ जी सर, बस मैं सर अभी कर रहा हूँ इसको, मतलब का क्वेश्चन लास्ट में लेंगे सर, जी लास्ट क्वेश्चन
मेरे ख्याल से दैट इज बेटर।
हाँ जी सर।
चलिए नेक्स्ट स्लाइड। Now this action we have seen, criteria I have already explained. Next. Renewal for 4 and 6A also I have explained that they have to apply under the same subclause, that is subclause 2 for AA, and now 1023C cases also under the same subclause they have to apply. Next. Yeah, now there is a condonation provisions are there. Those condonation provisions have been granted for all subsection 1 to 6. Because they have realized so many complaints and so many representation were there. So they say, yes, I will allow condonation of delay on the merits of the case. The CIT can condone the delay, and since if it is granted the condonation, then in that case it is to be treated as a file on the within the due date, and accordingly renewal or registration is granted. Now in that case, what are the simple reason according to some IT case laws? Say I have given some example which I have come across certain reasons, and it is not that sure short these are the reason you will get, because certain IT are giving different view and certain IT are granting that case to case. So some of the few reasons are illness of trustee, shifting of officer record, wrong advice or ignorance. Wrong advice and ignorance is not fully covered because they are saying ignorance is not the valid reason for condonation. Then clerical error by CA office, and then lack of digital access in the rural area, any other valid reason. So these are the reasons which you have to prove. You have to give valid evidences to prove that these are the real reasons for delaying the application. And if CIT is satisfied, he will allow the condonation. But here I want to put subclause 2 to 6 were given long back, around 4 to 6 months back. The utility were open. But for subclause 1, they have just reopened just 15 days ago. So now subclause 1 means the persons who have missed the original bus for re-registration. Now their 5 years period is also getting over. So this is the hierarchy in our department. But whatever, it's a good thing. At least they have allowed and they have opened one gate or window for those cases where things are they have missed the bus. And that application for condonation is to be filed along with the application 10AB. Yeah. So impact of rejection. Now suppose if you are granted renewal, then fine. It's good for next 5 years or 10 years as the case maybe you are being granted. But if it is rejected, then what will be the impact? The rejection of registration leads to cancellation of registration. I think after this slide, we will straight go for the form. The CIT may deny the renewal of registration and also initiate the cancellation proceeding at the time of renewal proceeding. And proceeding for cancellation is a very serious matter because we'll see on some other clauses, 115 TD provisions will apply. What are those provisions? You all are aware. I'll explain later on. The finance, no, let it be go back, please. Now the second is Finance Act substituted 12 AB 4 and 5 where if there is a cancellation of registration on a specified violation. Suppose a trust is doing a specified violation, then the CIT can initiate the cancellation procedure. Then now if substituted 4 and 5 where also it says a violation of earlier the 13(1)C, 13(1)D and 13(3) people, those violation 11 will not be granted. The heading was there and they were rejecting the whole exemption. Now with this amendment where there is a specified violations and a specified income. So if it is falling under a specified income, in those income to that portion of income, you have to pay the maximum marginal rate, that is 30%. Say if your investment is not done in 11(5), 13(3), some related persons you have paid unreasonable amounts, and 11(1)D, the corporate donation provisions are also not followed. And in some cases, 11(1)C means the activity outside India. If you have done, then in that case, your trust will not get the cancellation proceeding, but on that particular income, you have to pay the maximum marginal rate. So that is there. The Finance Act 23 years. Then again, they added one very important provision to specified violation. I'll read that because it is applicable to renewal. The Finance Act 20 added one explanation to provide that giving incomplete, false or inaccurate information in registration application will be deemed as a specific violation and can lead to cancellation. See, so now earlier there were three words were mentioned: incomplete, false, and inaccurate. Now here, with effect from 1/4/25, the word incomplete is deleted. Means if your application is incomplete, then they will not proceed for cancellation. They may ask to correct the application, or they may ask to submit the details, whatever is required to be done for that. and they can go ahead for registration or rejection. So here you have to be very careful. If you give false information or inaccurate information, your because not only the rejection of renewal registration will be there, cancellation proceeding will be initiated. And that's a very serious matter. Then not applying for re-registration. Now another 115 TDR, they have added some more clauses. If you do not apply for renewal, or if you miss, there is a condonation. But if you do not apply for first originally re-registration 1421, then now renewal if you are not doing, and if provisional registration also you have not applied for conversion into a regular registration, so there also the provisions of 115 TD will apply. And in short, provisions of 100 TD says a trust has to pay maximum marginal rate, that is 30% on the assets minus liabilities, and the assets are to be valued at the current market value. So it's a very serious matter if the trust is having immovable properties, and that too very old immovable properties, their value is very high, and so their tax liability will be in crores and maybe a big amount. Even if it is immovable property is not there, the calculation is also coming very high. So thing is this, you have to be very careful while applying. Please don't give any false information. Don't give inaccurate. And we chartered accountant, just to support and make happy our client, we give some false information and inaccurate figures also. I have a case wherein the chartered accountant has been sued for such mistakes. The trust has suffered crores of demand. So that action can be taken against us. So I advise, and one more principle from this amendment, I have my own finding, it is that inaccurate is better than false. You all will agree with me. In case there is an inaccurate application, it will not go for cancellation. But don't give any false information. Next. See, cancellation of registration, there are three reasons for that. Three processes are there. Occurrence of one or more specified violation, has received a reference from the cancellation or assessing officer. Now, assessing officer has come to know under 143.3 assessment that this trust has done some violation. So he may. It is not word is used may. It is used should. So AO has to give a reference to CIT to proceed for cancellation. It is the CIT will decide whether it is liable for cancellation or not. And third is any with the risk of management strategy formulated by the board from time to time. Next, please. Specified violations, there are there, but most important is the last one. Any activity carried on by the trust or institution is not genuine or not being carried out in accordance with or any of the conditions subject to which it is registered. So according to me, these specified violation, these things are covered. So in that case, you have to be very careful, because if not complied with the requirement of any other law is also there, it may lead to cancellation, but there is a change for cancellation and for granting registration. Granting registration, he has to just see whether compliance has been done or not. But for cancellation, he has to see whether that non-compliance has occurred, has either not been disputed or has been attained finally. Then only he can proceed for cancellation. Then 150 BPI, I think this is not to be just, I have given the information that what are the income to be taxed. So now documents to be attached. Self-certified copy of the trust deed, self-certified. There is a rule 71 prescribes all these things. Even the form 10AB also in the notes they have given what are the documents to be attached. Only thing I want to touch here, that Darpan registration is now become mandatory. Not officially, but it is now become mandatory. Earlier,
financial year accounts for the financial year 25 has to be given, or till 24?
See, the requirement says last 3 years.
Okay.
Now, 22, acha, nowhere they have mentioned audited accounts.
Okay, sir.
They're asking accounts. Now, of course, if audit is completed, we'll submit audited accounts. But 22, 23, 23, 24, you should file audited accounts. And 24, 25, if it is not complete, then provisional account, unaudited account, duly signed by the trustees, should be submitted. Then later on, audited accounts can be filed. The notes on activities, I have already earlier explained that you have to give the detailed notes, what are the activities have been conducted. And business income, if it is there, whether tax audit is applicable, then tax audit report is to be filed. Now, we need not file along with the application is audit 10B, 10BB, accumulation forms 9A, 10, or ITR or assessment orders. At this stage, it is not required. But be ready for all these things. They will ask during the hearing. Now, coming to the form. Now, here in the form, that section code is to be mentioned 01 for 12A, and for ATG it is 13. And it is it will come under the drop down. And for subclass 2, it is 01. In the notes, it is given. Like 10B and BB notes are given, detailed. Here also below the 10AB form, detailed notes are given. If you read those notes, I think more than half the questions will be solved yourself. Because they have given what is to be given, what is not to be given. Now that code number is 0102. From the drop down, you can select the correct code. But please check twice while selecting the code. Because wrong code will again create a problem. Then the clause number 3 is, you have to write, this is over. Whether your trust is charitable, religious, or religious cum charitable. Now, purely charitable, you tick there. If it is fully religious, you tick there. And religious cum charitable, you tick there. If a small activity for religious is done, or a small charitable is done, then you will fall under the third category. You have to tick there. Then actual activities as per objects. You have to mention the activities. So that as per the trust deed or MOA, you have to write whatever the activities the trust is permitted to do. Even if the primarily religious or a small quantum of charitable activities are done, you are going to the mix. Now, meaning of religious, I think it is already 6:20. I have given few judgment. Dawji Bora, Jamaat, Supreme Court has very clearly said some feeding of poor on religious occasion is a charity, not a religious activity. So even Shiva Shakti Shirdi Sai case also, the Hyderabad High Court has also said for universal brotherhood and teaching of Vedas and other script teaching is not a religious activity. Then Sripat Rampara Gurukul Trust Bangalore, there it said, this is also said, it doesn't involve offering of worship and prayer to God. So if it is not worshipping or praying to God, then it is not a religious activity. But that details can be read from these judgments. And there are many other more judgments are there which can help you, which is religious. And religious is not defined in the Act. Next, please. See, type of constitution, either you can have trust, society, company, or others. Generally, there are 3. But in Public Trust Act, where suppose Maharashtra Public Trust Act, the first step is to get the society registration, and then you are registered in the public trust. Your charity commissioner is acting in a dual capacity. He is registrar of societies as well as he is charity commissioner. So those 2 registrations are there. In that case, you should select society, because that is generally association go for society. So trust, society, or company, section 8 company, earlier 25. The society also register in Maharashtra, select the society. Date of incorporation is also they are asking. Now, date of incorporation, there are so many questions there. See, date of creation may be different from date of registration. You may register late, you may not register, that's a different thing. But in case of trust, the registered with charity commission, date of trust deed will be the date on which the trust is created, because the property is handed over to the trustees and the trust is formally created or incorporated on the date of trust deed, the day on which it is executed. The second is society. Society, it is the date of registration as a society. Thereafter, maybe Public Trust Act can be registered. Then Section 8 or Section 25 company, date of incorporation. Because license is granted, that is not the date of incorporation. The incorporation certificate date will be the date of incorporation. Now, objects of the applicant. Row number 5, where you have to write as per the trust deed and MOA. Not actually conducted, but whatever the objects of the applicant is to be mentioned. And there are drop down, you have to decide on the religious or various limbs of the charitable purpose. You can select various limbs. Next, please. Whether the trust deed contains clause that is trust is irrevocable. This is a very serious burning issue. Generally, the old trust deeds are not having this irrevocable clause. New trust, since we know in last 7 years, they are asking for this irrevocable clause in the trust deed, though dissolution clause is there. So in that case, they are rejecting the registration if there is no irrevocable clause. See, in Form 10A, when 5 years of original registration were applied in 21-22, so there was also the same question whether the trust deed contained clause that the trust is irrevocable, and the answer was yes or no. So whether if you tick to yes or whether you tick to no, you were able to go forward and submit the form. Now, in 10AB, if you write no, you cannot go forward. And if it is not there, you cannot write yes. So you are nowhere. So this irrevocable clause, there is no mention or no requirement in the law. But Section 11 starts subject to provisions of Section 60 and 63. Application is made in India for the purpose of benefits in India. Whether the application to societies or companies or only to trust, question arises. So this irrevocability clause is applicable to only to trust, not to society and not to company, because in Companies Act, there is a provision of dissolution. In society also, there is a provision for dissolution of the society, but so far as the trust is concerned, there is no provision for dissolution. At least in Maharashtra and Gujarat, you have to go to court to dissolve the trust. So here the problem is what to do if irrevocable clause is not there. If there is a clause for dissolution, that is not a revocable clause. That is just an indicative clause. In case of dissolution, then the assets will not be distributed among the trustees and given to other organizations having similar objection. So in that case, there is no directly mention of irrevocability. And in Indian Trust Act, Section 78 very clearly says that only the settler has power to revoke the trust. But generally, that Indian Trust Act is the provisions are mainly it is for private trust. No trust is registered under that. The states where there is no state law, say South of India and other states, there is no Bengal and other, there is no charity commissioner. So there they are registered under the old Registration Act 1810, I think. And they get it registered there, Register of Assurance, and then submit that to the income tax and go for registration under the income tax. So in that case, the advice is to change your trust deed and add this clause. Here in Bombay, if you at least produce that application submitted to the respective authority, then they are granting. So at least the trust has passed the resolution, trust has decided, and they have already submitted official application to the concerned authority for the change in the trust provisions, and irrevocability clause are there. But there are so many judgments. Few of them we have mentioned. See, there is a Tara education also there. It is in 2014 says that there is no need for the resolution clause. Radisson India Charitable Institution, Delhi, there also says in the absence of resolution clause, then irrevocable clause is not required. Here also the Charity Commission was not agreed to put the irrevocable clause. It is perpetual. Why it is required? So thing is this clause is creating a lot of problem and going to be a very problematic during the given time. Because 5 years ago, you were knowing this question, whether your trust is registered irrevocable clause or not. There you wrote no. So you have not done anything in last 5 years. So that now they are going to take it seriously. The form itself doesn't move forward. So even in Supreme Court, in one case, which is Raghbir Singh, wherein he has said that is irrevocability is not required. Settler is not there at all. So this clause is very seriously is to be taken. The department is not allowing without that, because some years ago, CNAG has submitted a report to the Parliament after doing the detailed audit of the charitable trust organizations. They have put a note that registration is granted even there is no irrevocability clause in the trust deed. And since then it has started. Anyway, this is a position for that clause. And one more is important is details of assets. So whether the registered Darpan is also, it was mandatory for FCRA registration, and those who were getting state or central government grants, they were required to register that. But there is an amendment made by the government in money laundering law, wherein they said for the charitable trust, they should have, or RBI should see that there is a Darpan registration. Now, after 1 year, the RBI has issued a new KYC statement, wherein in 2016, I think, wherein the RBI has asked all the banks to obtain the Darpan registration for all charitable trusts. Now, in a short time, they started freezing the accounts, and those things are going on, and the Darpan site was also not working so properly. But people have got registration, and almost it is become mandatory for all the charitable trusts. So for the Darpan, you have to give the details of the Darpan. Now, in Darpan also, if there is a change in the trustee, or in FCRA also, there is a change in the trusteeship, you have to intimate to them. See whether any application for registration has been rejected. Now, here the word is written only application. Now, whether it applies to all application or any other registration, but I think this is 10AB under income tax, and the re-registration is under income tax. So I think for all means we should consider that the rejection under income tax. So if there is but FCRA, if it is rejected, we can give that information. And if there is a rejection, you can give the details. There may be cases where the ITIT has set aside or quashed the earlier judgment. In that case also, I think the rejection detail should be given and a note should be submitted along with the other attachments that the ITAT has set aside or paused that order, and the further hearing is going on. Now, there is a claiming exemption under 1021. 1021 is applicable to research organizations where section 3512 or 3513 are there. You have to just mention yes or no. So there is no any details they are asking. Now, details of authors, founders. You all are aware that in audit report 10B and 10BB, we are supposed to give all these details. So almost every CA or every trust is having those details ready. Only thing is here they are asking on the day of application with their ID, relation, PAN number or Aadhaar number, address, mobile number, email address. And on the day of application, if there is a resignation, if there is a death, if there is a change, so that on the day of registration it is to be given. And if there is a more than 5% shareholding are there, those details are also to be given. Next, please. Now I'm going little fast. I don't mind up to 7, Ashwini ji. So here in yeah. So clause number 10, details of school, college, university, hospital, yoga institute, religious places, any other institution being managed, controlled, or administered or owned by the applicant. If those are owned by the applicant, those details are to be given in the form is there, format is there. You have to give those name, address, and the all details what they are asking. It's very simple. But only thing is if the trust is controlling any other school, college, university, hospital, then those details of those organizations are to be given. So controlled and owned, controlled, administered, managed, controlled, administered, owned by the applicant. So if the applicant is managing, then those details are to be there. And who is the person in charge is to be given. So that is one of the requirements of who are the person in charge for that. Next, please, Ashwin bhai. Thank you, Ashwin bhai, for assisting for changing the slide.
No problem, sir. No
If applicant has a business, so now business undertaking, 11.4 is a business undertaking. If any trust has received donation of or bequeathed any business, so that becomes business entity which is being undertaken by the trust, and that is continue, and those income is a income of the trust, and it is treated as a charitable, though that business is commercial. So there is the details of given such type of business, nature of business, address, whether separate books of account maintained or not, because we have maintained separate books of account. And business undertaking means it was a business conducted by someone, he has donated the whole business to the trust. And second section is 11.4a, wherein a trust is entitled to do the business if the nature of business is incidental to the objects of the trust, and separate books of accounts are maintained. So only these two conditions there, that business should be incidental, and separate books of account means separate bank, not separate account in the ledger, separate books of accounts in the sense that separate bank account, separate entries, separate balance sheet, separate audit. If it is tax audit is applicable, according to me, it is to be done, because they are asking to attach the tax audit report. So there also, if those cases are there, you have to give those details. Next, please. So if the applicant has any income in the nature of profit and gains of business, details to be given. Now, whether this 4 and 4A we have given, which is what is the meaning of incidental. Supreme Court, in the case of Oda, that is Ahmedabad Urban Development Authority, they have said the proper way of reading the reference term is incidental in 11.4a is to interpret it in the light of the subclause 1 of the proviso to 215. Means that the activity in the nature of business, trade or commerce or services in relation to such activities should be conducted actually in the course of achieving GPU. Actually to achieve the general public utility services. And the object and the income, profit or the surplus or the gain can then be logically incidental. So Supreme Court has also said, you all know that two judgment, New Era, Education Society and ODA. And ODA has also given one more criteria that if there is a reasonable markup in the business, if it is at the cost or less than cost or less than reasonable markup, then it is not to be considered as a business. But I have seen in many cases, department is CIT appeals are also not accepting that. Now, I think some more jolt is to be given to them in this matter. Then let us hope they will understand the matter. Now, details of all bank accounts to be given. That is IFS code and name and account and the current and saving and overdraft. And then now FD accounts are to be given. Separate disclosure in item number 23 for investment is specified in 11.5 you have to give. So automatic FD details will go into 11.5 details. So FCRA account required to be disclosed because SBI and utilization and disbursement account details are to be given because if there is FCRA designated account with SBI, Parliament Street branch, Delhi is there. Then limitation of 50 bank accounts in online form, give remaining accounts in annexure because in the form only 50 bank account details can be given. If it is more than annexure can be given. It means there are trusts having more than 50 accounts. All India, there are many trusts having many accounts. This is a most complicated and very difficult clause, next 114. Where it is been, they are asking details of all land or buildings or both. That slide number 31. I think now this has also become the most time consuming and things are asked which is seems to be immaterial. We have no idea why these data are collected, why these details of, the property when you have hold, how you have acquired, what is the date of acquisition, and what is the stamp value on the date of acquisition. I don't know for registration why these details are required. But anyway, government is collecting the data. They are asking these details. There are practical problems in these details. And particularly those trusts who are having very old properties, they are unable to find out. And in some states, Stamp Duty Act has come recently. In Maharashtra, it is from 70s, 76 or 74. The property acquired before that, there is no stamp duty. So stamp duty value, I think you can write the cost as a stamp duty value. Now, what is the value if you have received the property as a donation, gift? So their institute guidance says you can pass the entry at ₹1 or any nominal value and bring it to the books. So that value can be given and you can give the note on that this asset has been received by the trust as a gift on such and such year, and those details can be given. But stamp value is really in some cases not possible. Or you have to go to register office and take what is the circle rate or what is the ready reckoner rate and calculate SO meter and then you submit that. So that is really, I feel unnecessary and details which are not required for the purpose of registration. Anyway, pani burden. So these are the things they are asking. Here, what I said earlier, incomplete form will be better than false or incorrect form. I will not say in detail what I mean is, because incomplete can be corrected later on, can be submitted, that can be cured in the given time, because they have to pass the registration, they have to grant or reject within 6 months from the end of the quarter in which application is made. Now here, if 30th September will make submission, then the March will be the end. If it is extended, if we do the application in October, then it will be June. So we have ample time. In this case, this property details is really giving trouble to all. Many have got many questions. What information is to be given? So what I told you, you are intelligent enough to understand. Next, please. Now this has return is filed for which the last date is acquired, that is assessment year 24-25. Most of the trust must have filed. That's it. You have to give the information. There is no any other much requirement. So 17 to, that is the liabilities and assets and liabilities. You have to give corpus and reserves and other all liabilities. You have to give land and building and those. It means brief balance sheet is to be given. The latest one which is available. In fact, that should be a 25th. And then during the course of proceedings, they will ask you the up-to-date accounts. So here details of assets and liabilities, just the figures are to be filled up.
If the date of application are not available, then we can give figures for 31st March 24 or 25, which whatever is final balance sheet.
I'll give you practical solution. Whatever latest is available, you give. During the course of proceedings, you can submit those things. Because they will ask you a current balance sheet. Now here for the application, they are asking for last 3 previous years. So of course the details has to be given in the last previous year. Up to date is a big question. That can be given during the course of proceedings. Yeah, next please. Income received for last 3 years had to go on. There is a chart, grant received from central and state government. I think now Durga Devi Ma, the sounds are started coming. Now I'm just ending to it. But if that starts, then I won't be able to speak. The grant received from the companies under CSR, other specific grant and other income. The other income will be include interest, capital gain, other donations will all go in one figure in other income. So they want mainly grants from the government, CSR and specific grants and all other. And corpus grants are also to be included. Whether, yes, certainly that will be other specific grants. So general corpus donations to be included in other income. Yeah. So whether the trust has incurred any expenditure of religious in nature, these details are required for particularly for the purpose of ATG. So last 3 years, how many expenditure, how much for religious and percentage. Jai Mata Di. ये बंद करो ना. I've come to another room.
Not a problem.
Yeah, the connection is not there.
Battery is full. Yeah, some questions we can take, I think now.
Yeah, sir. Sure, sir. Yeah, the representation, the PPT I will share.
There are
now,
invalid round of rejection. I have given what are the invalid there and the case laws also there, which can be helpful to you in case of litigation or in case some rejection is made on those reasons. It will help you in ITAT.
सर क्वेश्चन ले लेते हैं पहले वो पार्टिसिपेंट के, देन फिर पैनलिस्ट के. पैनलिस्ट में अमरजीत कंबोज जी का है. कंबोज साहब आपने वोट ऑफ थैंक्स देना, वेट करो लास्ट तक.
ठीक है सर।
देन हाँ जी तनुष दुआ जी पूछिए जी क्वेश्चन, प्लीज शॉर्ट में रखना सर, क्योंकि वी हैव ओनली 14 मिनट मैक्सिमम। हाँ जी तनुष दुआ जी।
वॉल्यूम अदर हुए तो
सतपाल गोयल जी।
वही तो। हाँ जी बोलिए।
सतपाल गोयल जी। देन अंचल कपूर जी, नहीं सॉरी, देन प्रयास जी। आपको सबको मैंने अनम्यूट किया है। हाँ जी प्रयास जी। देन अनुराग अग्रवाल जी।
सर मेरा एक ट्रस्ट है, उसमें एक मंदिर है और साथ में एक हॉस्पिटल है, उसमें दोनों मतलब कि चैरिटेबल कम रिलीजियस ट्रस्ट है, उसमें कोई प्रॉब्लम तो नहीं है?
नहीं, उसमें कोई प्रॉब्लम नहीं। आपको मिक्स में जाने का है और देखना है कि आपका वो मंदिर में कितना खर्चा है और दूसरी इनकम और परसेंटेज क्या है। दैट इज टू बी सीन फॉर एटीजी।
नहीं,
अदरवाइज
एटीजी तो हमारे पास है ही नहीं।
हाँ बस, तो देन देयर इज नो प्रॉब्लम। Because in India, everywhere in the law, 11, 12, 13 or other sections, now religious and charitable, religious and charitable. So religious activity in our country, they have considered that it is a charitable activity.
हाँ जी अशोक जी, अशोक गोयल जी।
हाँ जी सर।
हाँ जी सर पूछिए जी।
आई एम तरुण फ्रॉम दीपक फाउंडेशन। मेरा एक क्वेश्चन ये था सर कि जैसे अगर कोई ट्रस्ट है, वो अगर ट्रस्ट जैसे हमारा सेकंड पार्ट में पूछते हैं कि वेदर एनी स्कूल, यूनिवर्सिटी, कॉलेज और हॉस्पिटल एडमिनिस्ट्रेटर मैनेज बाय एप्लीकेंट, तो अगर कोई ट्रस्ट गवर्नमेंट प्रोजेक्ट मिल रहा है, उसमें हॉस्पिटल रन मैनेज करने का हमें मतलब वन टाइप ऑफ मैनेज करने के लिए हमें सीएसआर प्रोजेक्ट या कुछ भी मिला है, तो उसको हमें वहां पे मेंशन करने की जरूरत है?
Yes, मैनेज, कंट्रोल, ओन्ड, वो सारी की आपको सिर्फ डिटेल्स देनी है। दे वांट टू नो to what extent activities you are doing. In case they want to come to you, so they want all these details.
हाँ जी नेक्स्ट जी मनीष गुप्ता जी।
सर मेरा क्वेश्चन है, जहाँ पे प्रॉपर्टी की डिटेल देनी है,
हाँ जी,
उसमें स्पेसिफिक परचेज कंसिडरेशन है ना, या अगर कॉस्ट ऑफ कंस्ट्रक्शंस भी उसमें इंक्लूड करके देना है?
yes, that I missed during the answer in the speed. You see, they have it is just mentioned acquired gift.
हाँ,
Now acquired means what? Even constructed is also acquired.
ओके। और सर मेरा एक क्वेश्चन,
Now the completion of construction can be given a acquired date, and the cost can be given, whatever the construction cost and the total cost is there, that can be given year, and those dates are available with you. Only thing is that you won't be able to find out from your record the stamp value. So in construction cost, practical advice, technical is different. You can put the same value as a stamp value. Because stamp duty cannot be charged to you on any market value or on that case, because it's a construction. You have done the actual construction activities.
हाँ जी अशोक गोयल जी, दिलीप जी, जीत तिवारी जी, एक एक करके पूछिए। हाँ जी संचित जी, हाँ जी पूछिए। हाँ जी
Loudly,
संचित जी,
please.
संचित जी पूछिए।
हाँ जी सर.
हाँ जी।
Sir, I have a query. I have a trust which is running a hospital,
Yes.
and they started with a small building and slowly they've been increasing the building size.
No, please repeat it. You have a hospital, yeah?
Yeah. So the hospital, they started with a small building, but now they have increased it over the years. The building has increased over the years.
Yeah, ठीक है. Expansion.
Now, expansion. Now in the detail where I have to give the cost of building, the area and the value.
Total,
How
as
do
on
I determine
as on today.
as on today?
Yeah, the old so much, give so much. Total, what area total that your
Hospital building is.
hospital building has got. That's it.
Okay. And do I
Total.
give the building separately and the land on which it is built separately?
If you can segregate, then segregate. Otherwise, put together.
Okay.
But there are, if you have purchased something with land and building, how can you bifurcate?
Right. Right.
I am Ashok Goyal.
हाँ जी सर
But
पूछिए।
according to me, these informations have no direct connection with registration. They are asking, fine. And there should not be any questions on that. That's what I say. Incomplete information is better than false.
हाँ जी शोक जी
मेरे दो क्वेश्चन है.
And if you put any column blank in that point, it will not move forward.
ओके सर
So if you are missing any one information, you cannot submit the form.
सर मेरे दो क्वेश्चन है.
Please, one by one.
लीज होल्ड लैंड की कैसे डिटेल दी जाएगी?
काय में?
लीज होल्ड लैंड है अगर स्कूल
लीज होल्ड लैंड सर लीज होल्ड लैंड
हाँ,
उसकी क्या डिटेल जाएगी?
उसकी थोड़ी जाएगी सर लीज होल्ड की अगर रेंट पे है लीज पे है आपकी लैंड
तो उस पे कंस्ट्रक्शन अगर स्कूल ने की है तो कंस्ट्रक्शन की
कंस्ट्रक्शन की जाएगी ओनली
कंस्ट्रक्शन की जाएगी, लैंड आपकी नहीं है.
ठीक है सर. दूसरा क्वेश्चन है कि सीआईडी ने हमारा एग्जाम रिजेक्ट कर दिया एप्लीकेशन. हम ट्रिब्यूनल में गए, ट्रिब्यूनल ने रिमांड बैक कर दिया और अभी हमारा केस पेंडिंग है सीआईटी एग्जामिनेशन के पास. देन व्हाट शुड वी डू? हमें
कुछ नहीं, you wait for their notice or follow it up with them कि भाई नोटिस इशू करो और इसका करो काम. And there is no time limit prescribed or any time limit in the act for set aside case.
तो हमें रिन्यूअल तो अप्लाई नहीं करना ना फ्रेश?
नहीं, क्यों नहीं, आपका पहले का एप्लीकेशन ही पेंडिंग है.
थैंक यू.
रिन्यूअल तो जिसका वैलिड है, आपका तो अभी गारंटी कहाँ हुआ है.
बट सर इसमें क्वेश्चन ये आ जाएगा ना अगर मार्च में मिलता है तो इमीडिएटली मार्च में फिर अप्लाई करना पड़ेगा.
That depends on facts of the case. आपको करना है तो तुरंत करना पड़ेगा और कंडोनेशन मिलेगा क्योंकि उन्हीं लोगों ने लेट किया है.
उन्होंने लेट किया सर. हाँ जी दिलीप जी, जीत जी, अरुण जी एक एक करके पूछिए. हाँ जी
हेलो.
हाँ दिलीप भाई बोलिए.
हाँ जी अरुण जी पूछिए.
हाँ सर, मेरा क्वेश्चन ये था कि जैसे बिल्डिंग कंस्ट्रक्ट की हमने, ट्रस्ट ने कंस्ट्रक्ट की लीज लैंड पे, और तो फिर ये परचेज कंसीडरेशन एंड स्टैम्प वैल्यू में जो मेरा कंस्ट्रक्शन कॉस्ट आया सिर्फ वही लिखना होगा?
Certainly.
और ये एक्वायर्ड एंड गिफ्टेड बोलता है,
हाँ,
तो व्हाट शुड आई मेंशन देयर?
नहीं एक्वायर्ड है ना, आपका गिफ्टेड थोड़ी है. गिफ्ट है ना,
Acquired.
somebody gifting you plot, somebody gifting you building, somebody gifting you any asset. So उसके लिए गिफ्टेड है या एक्वायर्ड है? एक्वायर्ड में यानी आपने आइदर परचेज और कंस्ट्रक्टेड.
हाँ जी अरुण जी, जीत जी.
Sir, good evening, sir. This is C. Arun Gupta.
हाँ जी अरुण जी.
Sir, last time when we the CIT exemption at Chandigarh, when we applied for the registrations, like we applied for religious come charitable, and the CIT was of opinion that it could be either religious or charitable. It cannot be religious or charitable. But you have to apply either for religious. But it was her opinion at that time, and ultimately they gave the registration for either. But they didn't deny. But they gave either for religious or charitable. But they didn't give for religious and charitable.
नहीं ना
So
साहब.
these type of opinions they are having of their own.
साहब, that is not correct.
Jayan Sahab and Kambosa might have also faced the
You
same
can
problem.
go in group and discuss with the CIT. All section 11, 12, 13, everywhere you
it is
read
written everywhere.
religious. And in the form itself, they are asking charitable,
yeah.
religious come charitable. Then
Right.
why this question?
So now if they have given the registration previously for charitable and now we reapply now.
That
for
is a
renewal.
different.
For renewal.
If you have done mistake earlier writing only charitable and now you are asking mix.
No.
Whether you have changed your activities, trust deed you have amended.
No, sir, in the application we write both religious and charitable, but they gave the registration either for religious or for charitable. Now what we should do? This way.
आपको, if it is come, you go for come column and you see.
Okay.
They have to grant it, sir.
Yes.
अपना देश में religious तो वो charitable से भी बड़ा है.
Yeah. And sir, if a mandir is having a shops within its present, that's rent is coming from those shops to the mandir. But that is not a commercial activity, no?
Certainly, it's a commercial. They are treating as commercial. And you have to see whether it is 20% exemption में आ रहे हो कि नहीं.
Okay. If it is more than 20%, then
yes, then you are facing 215. But 215, if it is applicable, then you have some benefit of section 1310.
Okay.
You read 1310, they will allow you all the expenses.
Okay.
Yeah.
Okay. Thank you, sir.
Sir, if any tract have branches in different places,
yes,
then a detail of all the branches to be given.
Yes, it is clearly mentioned in the form. all branches you have to give. सब आप ये समझ लीजिए, मैंने इनडायरेक्टली बोला कि अगर वो आपके आना चाहते हैं तो कहाँ कहाँ आएंगे, समझ गए आप?
थैंक यू।
हाँ जी, जीत जी का हो गया। हाँ जी सर, सुमित विजय जी,
बोलिए सुमित
राकेश
जी।
गुलाटी जी, बलबीर सिंह जी, संजीव चड्डा जी।
आप कितने
बस मैं
क्वेश्चन हैं?
लास्ट जो अनम्यूट कर रहा हूँ, इसके बाद कुछ नहीं करने जी। लास्ट जो 4-5 जनों को किया सर, आप क्वेश्चन पूछिए। राकेश गुलाटी जी।
हेलो
बोलिए।
माई सेल्फ इज
सर।
संजीव चड्डा।
हेलो।
हाँ जी
हेलो।
राकेश गुलाटी जी, हाँ जी पहले
हाँ जी,
पूछिए।
हाँ जी सर, एक ट्रस्ट थी जिसकी हमने प्रोविजनल रजिस्ट्रेशन मिली थी। CIT has applied the provisional registration. We applied for the permanent registration, but it has been rejected ex parte because we are not able to furnish the documents over there.
So you went to IT.
IT has remanded back to CIT to give an opportunity to re-decide the case. Now, whether we should apply for the renewal now?
No, your earlier application is pending. I have given the answer in the earlier question.
Okay.
Why your earlier application is pending?
संजीव चड्डा जी।
गुड इवनिंग सर।
गुड इवनिंग
सर
बोलिए संजीव जी।
हाँ जी सर, एक एजुकेशनल सोसाइटी है जिसकी हमें ये एग्जाम्पशन सर्टिफिकेट 2026 तक मिला हुआ है ऑलरेडी, लेकिन
26 यानी असेसमेंट ईयर 26, 27, 31 मार्च 26. ओके।
yes, but at that time the limit was more than more than 1 crore at that time ना, कि 1 करोड़ से ऊपर अगर रिसीट एक्सीड होती है तो एग्जाम्पशन लेनी पड़ती है। लेकिन अब ये 5 करोड़ हो गई हुई है 1023C 380 में, तो क्या हम दोबारा रिन्यूअल अप्लाई करें?
सब देखिए 1023C 4, 5, 6 and 6A is gone.
Yes.
3 is still there.
Yes.
और 3 के लिए आपको कोई ना ही रजिस्ट्रेशन, ना ही ऑडिट, ना ही कुछ, स्ट्रेट यू कैन क्लेम दैट एंड यू आर अलाउड.
Yes, that's the case. Till now, it is below 5 crore rupees.
Yes.
So, should we go for that 12A return filing or 1023C?
आपको जब 1023C 3AE AD AF जो भी है वो अवेलेबल है, तो आप उसमें ही जाएंगे. आप टोले लेने क्यों जा रहे हैं? या आप अगर टोले लेंगे तो फिर आपको 1023C नहीं मिलेगा.
हाँ, वो नहीं मिलेगा। और लेकिन जब 5 करोड़ से ऊपर एक्सीड कर जाएगी उस टाइम फिर दोबारा लेना पड़ेगा।
नहीं ना, हाँ, वो तो फिर आप जब भी चाहे ले सकते हैं. लेकिन आपने पास्ट में एग्जम्पशन क्लेम किया है कि नहीं, दैट क्वेश्चन विल अराइज.
तो एग्जम्पशन तो क्लेम हम कर रहे हैं इसके अंदर अभी.
सो आपको रिन्यूअल के वक्त ही आपको अभी जैसा अभी आपको यहाँ तो प्रोविजन है कि आप टोल में रजिस्ट्रेशन ले सकते हैं. क्योंकि आपको हॉस्पिटल और एजुकेशन इंस्टीट्यूशन ये दो को ही है. सबसेक्शन 3 अप्लाइज टू बोथ.
हाँ जी. नहीं तो फिर इसमें अब क्या किया जाए, रिन्यूअल अप्लाई किया जाए?
Sir, the question is, the person is having registration under section 12AB presently.
Yes.
But he is also eligible for 1023C3AD. Whether he can go for 1023C3AD or is it compulsorily required to file return under section 12A?
If you do not apply, then your 12A will go. Yes. सुनिए मैं आपको
TD will be applicable, na sir?
Yes. 115 TD will apply. In this case, you should apply for 12A.
Yes. This is what the answer is.
Because if you are earlier he said he is not having 12A. If he is having 12A as well, you should go for renewal. Otherwise, 115 TD will apply.
टैक्स देना पड़ेगा.
That is very.
जसवंत जी लास्ट क्वेश्चन.
My question is same यार.
नहीं.
Okay. Same answer.
Same.
चलो जी सर, अभी कंबोज साहब का और सुभाष जी का कोई क्वेश्चन है तो वो ले लो सर. सोनी साहब का भी है क्या? नहीं, सतपाल जी का. सतपाल जी आपका क्वेश्चन हुआ नहीं जी?
सर मेरा क्वेश्चन ये है, सतपाल जी का हो गया.
सतपाल जी का हो गया.
जो स्कूल्स, बुक शॉप एंड ट्रांसपोर्ट चला रहे हैं, बसेज अपनी है उनकी,
ट्रस्ट चलाता है.
11(4)A में कवर होगा जाके वो जनरल?
नहीं, आपका ट्रस्ट क्या क्या चलाते हैं?
रजिस्टर्ड ट्रस्ट है, ट्रस्ट स्कूल चला रहा है.
हाँ, स्कूल चला रहे हैं. और
स्कूल चला रहे हैं, स्कूल में बुक शॉप है और ट्रांसपोर्ट भी है, बसेज है उनकी अपनी बच्चों को लाने की.
there is a judgment, I think, High Court ka hai. I don't remember citation. It has said that these are all incidental to the education and it is to be treated as
सुप्रीम
education.
कोर्ट न्यू नॉवल में सुप्रीम कोर्ट ने कहा ये बात,
Yes.
सुप्रीम कोर्ट ने, लेकिन क्वेश्चन ये है कि क्या ये एक्टिविटीज 11(4)(a) में फॉल करेगी?
नहीं ना, normal education.
नॉर्मल एजुकेशन में.
That judgment is very, very good judgment that. Even सत्य साईं बाबा ट्रस्ट को भी जो बुक्स का था वो उसको इंसिडेंटल में लिया ही है उसको.
Sir, second question is, in the cases where you have answered, in the set aside cases which are pending with CIT exemption, registration is pending now. As on date, registration is pending. How to file ITR, whether to claim exemption or we are to file in the normal way.
आपका जो पेंडिंग है वो कौन से सालों के लिए है?
Current year assessment 25-26.
तो 25-26 तो है ना आपका?
जी सर.
तो 25-26 में तो क्लेम कीजिए और रिटर्न भरिए. और 26-27
कुछ केसेस में जो 24 वाला था 24-25 में खत्म हो गई.
There you will face the problem. आप कोशिश कीजिए कि ये इसके पहले मिल जावे आपको ड्यू डेट से.
अगर नहीं मिलती तो एग्जम्पशन नहीं है तो रिटर्न उसके अकॉर्डिंगली भरनी पड़ेगी.
आप देखिए आपको अकॉर्डिंगली भरनी पड़ेगी, लेकिन
अदरवाइज सर फॉर्म ही नहीं जाएगा. फॉर्म 10B में वो मांगेगा ना रजिस्ट्रेशन नंबर एक्सेट्रा.
आपका नंबर मांगेंगे.
एग्जम्पशन अवेलेबल ही है नहीं, क्लेमेबल ही है नहीं फिर.
हाँ.
राइट सर.
सर ऐसे केस में 154 फाइल हो पाएगी?
नहीं साहब, इट इज नॉट मिस्टेक अपरेंट फ्रॉम रिकॉर्ड. आपको अपील में ही जाना पड़ेगा.
इसमें 154 भी अप्लाई नहीं होगी.
मिस्टेक अपरेंट फ्रॉम रिकॉर्ड नहीं है. आप 154 कैसे जाएगा?
119(2) में जाना पड़ेगा. 119(2) में जाना पड़ेगा.
अपील
अपील भी नहीं होगी. 119(2) में जाना पड़ेगा.
वो भी हो सकता है. 264 भी.
Exemption is granted later on from this.
Then आपके पास अगर असेसमेंट है 264 भी जा सकते हैं आप.
Yes sir, 264 भी जा सकते हैं. Yes.
जो भी जा सकते हैं आप.
Right sir, thank you.
चलो सर कंक्लूड करें सर.
प्लीज.
कंबोज जी का लास्ट में फिर वोट ऑफ थैंक्स है. तो मैं सबको
वो सबका क्वेश्चन था कि आपने रोक दिया था.
क्वेश्चन भी है सर आपका?
नहीं, क्वेश्चन नहीं है. Just to add it. The most hot topic is the set aside cases. Yes. My humble view is that while arguing the cases before the Honorable ITAT, one must request for some time limitation, because I did so in some cases and the Honorable bench granted. They marked it there that the appeal should be decided
within 6 months.
Within 6 months, 3 months or so. Because this is before every bench. And this is the general problem the members are facing.
And I just add to here, there are more rejection than granting.
Yeah.
That is one thing. Another thing, most of the cases, the ITAT is giving judgment in favor of the SSC.
Yeah.
And here in Bombay, the ITAT is just 10 minutes taxi drive away from the exemption office.
Yeah.
They take 3 to 4 months to send the official copy of the order. And they will not start hearing or sending the notice till they receive that official copy.
The official order.
I have represented. It's a digital era. You are asking everything online. Can't you check that order online?
Yes, of course.
So, see, but they say our rule says like this, we cannot beyond go. The rules are to be amended. I said, this is hierarchy.
Sir, just before the webinar, I downloaded one of my judgment from ITAT side and just filed the application online for giving the appeal effect. It is surprising. You are perfectly all right, sir. But this is the mindset of the...
You are from which place?
I'm Ludhiana, sir.
Ludhiana.
Yeah.
So, आप वो तो जजमेंट आते तो कितना टाइम लगेगा? Yeah, please चलिए. Let us conclude it, please.
Yes, sir.
सर थैंक यू वेरी मच सर. मैं उससे पहले अपडेट, आई एम थैंकफुल टू सबसे पहले विपिन बटाविया जी की, उन्होंने अपडेट कर दिया अबाउट द डेट. एंड देन संजय अग्रवाल जी, जो मेरे पास भी इंफॉर्मेशन है फ्रॉम माय अनदर पर्सन, वो यही है कि ऑल द एप्लीकेशन has been application for extension has been moved with the representation as well as with the High Court petition, and hopefully the decision may come soon, maybe before 26th, because on 26th there are many High Court
I
already
expect
fixed for
25th.
hearing. May it be Punjab, Haryana, or Rajasthan High Court. I think before that, or either on 25th or 24th, we will see there is a date extension with the positive note. Thank you very much. I request Amarjit Kambojji to propose the formal vote of
Thank you very much, Ashwini-ji. I will just take a minute's time only. Such a great, excellent deliberation and attending so well to the queries of the participants. Thank you, Ashwini-ji, for such a good timing to invite Vipanji to enlighten the members on such a hot topic, which is every member is facing the queries and the problems. Thank you very much. And thank you very much, Vipan sir, for giving such a elaborate. It is such a topic. You have very rightly said that so many benches are hearing all these appeals. And I quoted many times that on all the journals I have taken on online, 20 to 30% judgments are on the charitable institutions. And most of them are in favor of the SSC.
SSC.
Because I'm surprised how this section of the department is working against the charity. Because I think they have a mindset that there is no such charity and everything is just they are doing the business only. Particularly in case of the educational and the medical hospitals cases. Sir, thank you very much for enlightening the participants and sharing your views and making the things very, very clear. I'm very grateful. Thank you very much. And thank you to all the participants who have attended this webinar in a large
special
number.
thanks to participant. आज के दिन जब सभी कार में busy हैं, even though more than 330 participants were there.
And thank you to the Voice of CA also for organizing this. And in the last, I will say, now we are proposing to grant a degree to the Ashwini ji. वो कहते हैं ना जी टैक्स गुरु है, ये जीएसटी गुरु है, तो ये हमारे वेबिनार गुरु हैं जी. So he is organizing the webinars in a very, very excellent and in a efficient manner. Thank you very much to all. Grateful, sir.
Thank you very much. And anytime welcome on Charitable Trust.
Thank you, sir.
So nice, sir.
जो भी होगा.
So nice, sir.
Okay.
Thank you.
Bye, everybody.
Thank you.